My name is Darrell Bennett, Come Back Swinging. And I do want to cover today about pleas. The two types of pleas. We're going to talk about open pleas and we're going to talk about closed pleas. We're going to talk about who the plea, the difference between a plea agreement and a plea deal. Spoiler alert, there is no difference, but sometimes people use them and use them as if they're different, but I want you to know. I also want to talk about how the practical effect is. Every time that I talk about the law, because of those of you that know my story, any parts of my story, you know that I know the penal system both from a practical standpoint and I know it from a theory standpoint. So that's what makes me different, because you have some people that just talk about one side or the next. I have an acquaintance that's a prosecutor, and he and I were having a long conversation where I said, yeah, you say all that, but that's not really how it is in practice. He said, well, obviously I practice. I'm a prosecutor. I said, no, you practice with the arm of the state. You haven't practiced where the arm of the state has been against you, and it's totally different in that setting. So let's get right to it. First of all, I want you to know that there are two types of pleas. There's an open plea and there's a closed plea. Open plea and a closed plea. Oh, let me step back before we even get to that. What is a plea deal? What is a plea? A plea is when someone says or gives an oath that they have committed A, B, or C crime, and they are admitting to a conviction. That's what a plea is. So just because someone pleads does not mean that there is an agreement. A plea happens in court, and there's a number of steps that are taken, generally whether it's state or federal, regardless of the state, where they ask, was it voluntary, was it knowing? So let's go back to my example here of a closed plea. Let's say the closed plea says the defendant will plead guilty to first-degree burglary, right, on this hand. The prosecutor will agree that they will ask the judge or recommend to the judge a sentence of 7 years. And let's just say there's nothing else included in the agreement. So each side is getting something. The prosecution is getting this pushed off their table easily, and they know that they won't have to go to trial because the defendant is saying, I'm giving up my right to a trial by jury. I'm giving up my right to a speedy trial. I won't even say my right to a fair trial because you're probably not going to get one anyway. But I'm giving up my right to the charade of a trial. And the defendant in turn is getting and knowing that the prosecution is going to ask for, in this case, the term of 7 years. This is where people get messed up. Now I'm talking about a closed plea. This is where people get messed up. If you don't recognize the language here, you will think that because the defendant signed an agreement with the prosecution, that binds the judge as to what the sentence will be. That's what you have to understand. That's not the case. Because the prosecution, all they can do is recommend a sentence. They are not in a position to actually do the sentencing. That's where the bait and switch happens. You want to know how many people I know who signed a plea deal for whatever crime or series of crimes. It was a closed deal, meaning that the prosecution agreed that they would only recommend a certain amount of time. And let me be clear on this. And the defendant thought in their mind, this means that this is the amount of time that I'll get, not realizing that it is the judge that makes the ultimate decision and is the determining factor as to what the sentence would be. So let's take defendant. Defendant says first-degree burglary, signs, 7 years. They end up going to the sentencing. They get to the sentencing. The judge says, I'm looking at your criminal record. I'm looking at the fact you've had arrests. I'm looking at the fact that you took a plea, but you really don't seem remorseful. They do that too. You took a plea, but you really didn't seem sincere and honest in that plea. So I'm going to determine that you really have not taken ownership over what you did. So therefore, I am going to determine that you will serve 120 months, which is the equivalent of 10 years. Now the person is in the unfortunate position to try to figure out how to unscramble the egg. And this is where you have people that want to now try to take back their plea. They're trying to figure out why they signed for 7 years, but yet they got a sentence significantly different. And that is because, one, the judge can determine the sentence that the judge wants based on a number of different factors that may or may not have even been considered in the plea agreement itself. Secondly, because the agreement only states that the prosecution will recommend a sentence, and the judge, of course, can choose to deny their recommendation. And thirdly, because there may have been loopholes, and this is what I want to talk about here, loopholes in the plea agreement. So let's go back to the person. The person said they would sign an agreement. The agreement said they would plead guilty to first-degree burglary in exchange for the prosecution saying they would not bring any other charges, and the prosecution saying that they would only recommend 7-year sentence for this. Right. Sounds cool. Because there are a lot of people who sign agreements, they don't read everything, or they read what they would like it to have said rather than what it had said, they miss things. So I want to give you some specific things that if you know somebody's looking at a plea agreement, they need to look at. The first thing that it might say is, this plea is subject to change if other information is found out concerning the events that took place. So let's go back to the original thing, right? Let's say the person said, let's say it's first-degree burglary. I don't want to draw out the scenario here, but generally with first-degree burglary, someone went into a home. It doesn't have to be, but generally it was a home, and somebody was occupying that home. And so the person went into the home. Maybe they didn't have a gun because it's not armed burglary or aggravated burglary. It's just regular burglary. So they probably didn't have a gun, but they went in and didn't have a weapon or whatever. They went in. Someone was living there. It was a home. It was actually occupied. And so, hey, that happened. Now, they signed this plea not realizing that there was still an active investigation happening. Somewhere between when they signed the plea and when they land in front of the judge, maybe prosecution and law enforcement was looking through their social media. Maybe they were talking to other witnesses. And they realized, you know what? No, they did have a gun. It was just that they never found it at the scene. Prosecution can then choose to revoke the plea. And they could either start it all from the beginning. They could either offer a new plea agreement, or they can just bring that information up in the middle. Oh, by the way, there was a gun. So we're no longer held to only recommending 7 years because that 7 years was based on what we thought the events were at the moment. Also, what you should look out for is even if nothing changes in the understanding of the events that took place that brought the person in the crosshairs of the legal system, it could be a situation where, because this is another thing that they'll say, if things are found in your background that lead to, if things are found in your background, we might choose or could elect to choose to push for a higher sentence. So let's say during the negotiations between the defendant's attorney and the prosecution said, look, the best we can do is 7 years. And whenever they say the best we can do is as if they're doing some of the time, but whatever. The best we can do is 7 years. And that's what it's going to have to be. But your client only has 2 arrests, right? Well, yeah, or 2 convictions. They might say, yes, there's two arrests, 2 convictions. That's what my client told me. So now all this is signed. Then they end up getting to the penalty phase. The investigation that the judge orders from a completely different department, generally Department of Probation, but somewhere within the penal system, comes back and says there were actually 3 convictions that the person had. Now the prosecution can say we're no longer held to those 7 years because our agreement was 7 years based on first-degree burglary and that you only had 2 convictions. Now that we realize you had 3, we're going to push for a higher penalty. And so the defendant, and I've seen it happen to people, they will get angry and say they're reneging on their deal or they are violating the agreement when the person never realized you signed an agreement which left it open for them to still continue to investigate to find other things. Because generally, look, when people are being offered agreements or there are negotiations on the table. And I mean, I get it. The person that's a defendant wants to put themselves in the best light. So then, if they're thinking in their mind that the prosecution only knows about two convictions, and this happens more than not, the defendant's not going to be the one to disabuse them of that knowledge. Just, hey, let's just hope it goes. And I mean, I've seen many cases where because of a thorough investigation, it never gets found out. I mean, because the investigation wasn't thorough, it never gets found out. But if the defendant knows that there is more in their past, and that agreement does not take that into consideration, understand, and I would advise whether it's a friend or a lover or someone that's your in your family, advise them that you are taking the risk that once that is uncovered, the entire deal is thrown out, and now you're stuck with a guilty plea, and the prosecution doesn't have to honor their end of what the recommendation would be. So really, you're screwed on both ends. It would have been better if you just didn't take the agreement, if you said from the beginning you were going to take it to trial, because now you ended up taking a plea and then not having the benefit of the defendant's or the prosecution's promises on the other end. Those are some of the small ways. Some of the other things that is very common, even in the federal system, is that when a person takes a plea, in many cases, what they'll do is they make the prosecution will include in the agreement that the defendant cannot appeal the sentence. Usually it'll say, unless they got higher than a guideline range. And I don't even want to talk about that because that could be a whole other thing, but I'll talk about it, but I can't really get into long terms on it. Let's say the guidelines for a particular, let's say it's first degree burglary, and the guidelines, and I'll do a whole thing on this one day, the guidelines are going to be based on criminal history as well as the circumstances of the issue itself. Let's say the guidelines say for this particular crime and what took place, the guidelines are the person can get anywhere between 7 and 12 years. But the agreement here, because the agreement, in order for it to be enticing, has to either be lower than that or the low end or somewhere. The agreements, the guideline is 7 to 12. The defendant is aware of this, just with that one charge. The prosecution comes and says, look, you plead out to it, we'll recommend 7. And we'll call it a day. But part of it might be, and again, because people don't read the whole plea, they end up getting in this circumstance. It might say you can only appeal if you end up getting more than the guidelines, not more than the recommendation. So let's go back to sentencing. Now there's sentencing. The judge says, my guidelines are 7 to 12 years. Judge doesn't mention the plea agreement because it's not, again, the judge has nothing to do with that. That was in the back between you and the prosecutor. They are aware of it, but that's how to get away with it. That's in the back. That has nothing to do with them. So now they say 7 to 10 years, 12 years, we'll split the difference and round up 10 years. So the person walks out, they think in their mind there's some level of consolation. At least I can appeal because they recommended 7, but the judge gave me 10. And it's not until they reread the plea agreement at this time, usually it's after they've been convicted, after they've been sentenced, and now they're sitting in somebody's maximum security prison, that they reread and they recognize that actually the language said not that you could appeal if you got more than the 7, which was the recommendation. You could only appeal if you got more than the guidelines, which was in this case 12. So again, the person ends up screwed. So what is the practical effect of what I'm talking about? And then I want to talk about one of my recommendations for how we can have systemic change. Because people talk about systemic change, I want to tell you one of the things that we can do. First, let me talk about the practical effect. The practical effect is that most people who who are in prison. Most people who have convictions pleaded. They were not found guilty. That's the first thing you should understand. I mean, I don't have the numbers offhand, but it's definitely over 80%. Why? Well, it's a number of reasons why. Sometimes it's fear. Sometimes it's realizing and knowing there's something called the trial penalty. Of course, they don't tell you this in law school, but you learn it when you're actually in the practice of the issue. That the trial penalty is, prosecution lets you know, if we got to take this thing to trial, oh, we're gonna work to make sure you get the highest penalty. And judges often, though they may never say it openly, most judges are very keen to suggest, if not outright say, if you end up getting found guilty, which may be through a jury, we are going to give you the maximum punishment. So take that first-degree burglary, then they have 7 to 12 years. They might be thinking, forget the 7 years or the 12 years. If I take this thing to trial and they tag on some more charges, I might end up with 20 years. So the one reason people take pleas, one, because I know the question is, well, why would you plead if you're not guilty? I can tell you a number of reasons why people plead if they're not guilty. I already said one is fear. Not guilty, let me just say this, does not mean that the person didn't do something wrong. Let me go back to the first degree burglary, because I want people to have clarity on this. Let's say the facts are, and this is I know someone where this happened to. Two people decide they're going to go into a dwelling or structure and they're going to steal something. They go in, they don't have weapons, so it's not aggravated, but they go in and they steal some things out of the structure. Now, they're charged with first degree. Part of their defense to the attorney might have been, well, it was an abandoned building. Now, in your mind, you might think it's no difference between an abandoned building, a business, and a home, but in most cases, in most states, the law does differentiate. So in many states, the difference between first degree and second degree burglary is that first degree generally is a home, and it is a home where people are dwelling in. So if you're able to prove that was an abandoned building, it doesn't mean that you still didn't have ill intent. You didn't go in. It doesn't mean you didn't go in and try to steal. But what it means is that person, if they're able to prove, let's say that it's an abandoned building, now it's an entirely different discussion. Now it's second degree as opposed to first degree. So that may be the difference between someone being having a sentence of 7 years and maybe 3 years, just based off of that. So I want to first give that one point, because I know people say, well, if you did something, why do people plead if they're not guilty? A lot of people take pleas even though they might not have been guilty of the thing, but because they knew they did wrong, they know people won't believe them. Let's take it further. They're charged with aggravated because, let's say, and this happens often, it was a gun found or weapon found near the site of where they were apprehended. Their fingerprints weren't found on it, but the police have said they threw it out when we were chasing them, and the prosecution is running with that story. Now, the backstory might be this person already has maybe an aggravated burglary on their record, or they have some sort of violent assault, or they just have some sort of criminal past. They know that even though they may not have had the actual gun, and they know that even though they might be able to prove at a trial that they didn't have the gun, which could be the difference in this case between aggravated first-degree burglary, which could be a 25-year sentence, and just first-degree burglary, they don't want to take that chance. And many times prosecutors will be very frank and talk to the defense attorney and say, you know good and well when we take this to trial, they're going to believe me, meaning the jury. Because when we bring them out, like I knew one guy, he had his hair up in spikes and he was growing it out. And I was telling him, I said, bruh, right now, you are in federal custody for a very serious crime. You need to cut your hair. He's like, it shouldn't matter what it is. I'm standing in front of the judge. Okay, all right. Because what they're going to do is they're going to paint you out to be a thug. You want to look like a thug? They're going to paint you out to look like what you want to be like. And so what I want you to understand is how so much of this happens in the shadow of the law. The prosecutor might know too, or at least kind of believe. We may not be able to wholeheartedly prove it, but by the time we get finished talking to the jury about their record and we bring them up there and they got the tattoos and they're buff and they're dark and they're black, it's not going to be hard for me to convince them that, yeah, they threw that gun out the window when we were chasing them. They threw the gun away. So what does the person do? The person thinks aggregated first-degree burglary, it could be 20 to 25 years. They said they'll drop it down to first degree. It'll be 7 years. Let's just do the 7. Or you have to take the aggravated, or they say you take the aggravated, but we'll only push for 7 years. So the person pleads to something they know that they weren't a part of. They did do wrong, But they weren't guilty of that offense, but they plead because they know if I push my luck and I take it to trial, they're going to, I'll give you a colloquialism that's said on the inside of prison, they're going to knock your head off. That means that when it's all said and done, and I know people, I knew one guy in particular, he was being charged with a shooting. And he said once they see the records of the camera, it's clearly that's not me. By the time they showed the records of that grainy image, which could have been any black man, he had been offered 10 years for the shooting. He's sitting in prison now on his 15th year. They gave him a 30-year sentence by the time he took it to trial. And yeah, he had stuff in his backstory. So don't get me wrong, he wasn't an angel. He had stuff in his backstory. I think he had another shooting on his record. By the time they finished with him, they made him look like America's Most Wanted. And now and somebody even said to him, because I think when I met him, he was in year 10 or 12. Somebody said, I bet you wish you would have taken that 10 years now, because with 10 years good behavior, you may have been out at 8. Now you're on a 30-year sentence because you decided to play with them. And because they know the prosecution, they know they have the arm of the state by their hand, and they know that people say these things to each other, people are scared. So you will be surprised when people will plead to. They'll plead because they know, one is fear, 2, they know the optics. You already had a shooting, or let's not make it violent. You keep getting charged with smoking weed and selling weed. So it's not going to be hard for them to say that you did a burglary. It's really not going to be hard. And you didn't graduate high school, or you graduated but you really don't have a job. All of that stuff is going to come out. And by the time they finish messing around with your character and they nibble around the edges on stereotypes, it's going to look completely different. So the second reason people take pleas is because of the optics. They know that it doesn't look good. The third reason that people take pleas is because they just want to get it over with. A lot of times people don't talk about that. They just want to get it over with. Some people are sitting in maximum security jails, not prisons. I don't even have time to talk about the difference between the two. But jails, which is far more uncomfortable than a prison, because jails are only meant to hold people for months, not years, whereas prisons, they make them for people to be there for decades. Sitting in maximum security jails for years, fighting their case. Now, I know I said they're not meant for you to be there, for people to be there for years, but people are there for years. But people will take pleas, and you would be surprised, perhaps, by how many people do it because they just want to rush it along. They want to rush it along. They feel like, let's go back to When They See Us, Netflix, Central Park 5, what they did with them. They said, look, you sign this, it'll kind of all be over. You'll be surprised how many people they do that to. They say, look, it'll be 7 years with good time. You might do 5. You do a program in the state, you might do 2.5. Meanwhile, you start thinking about your friend who you know got charged with a similar thing. He's militant. He gonna fight it out. He been in there for 4 years fighting it. So you're thinking to yourself, do I take the 7, maybe be out in 2.5, moved on with my life, or do I fight it out and I be like that guy who's now stressed out, 4 years sitting in a maximum security jail trying to fight this back and forth. And now what was one charge turned into 4 different charges. And that's a whole nother thing. So that's the other reason people do it. They just want to move the process along. I think people will be surprised to know the emotional toll that legal issues take on people. It's not just the financial toll it's the physical emotion. It's the fact people start losing their hair. It's the fact people can't sleep. You think you worrying over whether or not you're going to get a promotion or whether or not you're going to lose your job because of COVID has kept you up at night. Imagine if you thought to yourself that somebody else had the decision to make whether or not you spent 20 years behind the wall. That's a whole nother level of stress. I promise you. I promise you. I can give story after story after story. I can talk about the one guy I knew who was my barber on the inside. And he said, and we knew it, he was facing the death penalty, which is very rare in a federal case, but he was facing the death penalty. They were charging him with 9 bodies. And he said, you can't imagine the stress I'm under. 9. So even if you beat 1, I promise you, they're going to get you on 1 and a 9. So it becomes a situation where people take pleas because of fear. They take pleas because they want to move it along. They take pleas because they know the optics. And the last reason is Some people just take pleas because they're totally ignorant of what lies on the other side. Sometimes they lie to, sometimes they're misled, sometimes they believe what they want to believe, and they think it's one thing and it's a total different thing. I can't tell you how many people sign things and they look back and they realize they have signed a deal with the devil. No pun intended. They've signed something and they signed away their right to appeal. They signed away their right to really argue. They signed away all types of rights and things that they had, and then they end up getting a sentence higher than what it was recommended that they would get. And so you have people that sign because they think, one, this is why I wanted to start with the misconceptions first. They say things like, well, the judge is bound by it. And they think that. And because they believe that the judge is bound by what it is that they say, or what the paper says, they sign it, not realizing the judge is not bound. Or they think that because it's been signed, even if the judge is not bound by it, it's like ironclad. Or they believe somehow, it's a lot of ignorance that goes into it because people just don't know the law. And people think that because they've been ensnared by the law, that because they studied the circumstances of their case that they know the law, but there's other laws that are affecting their situation that they're ignorant of. And then when I say ignorant, I don't mean in a malicious way. I mean that in the best light. They just generally don't know. My people are destroyed by lack of knowledge. They just genuinely don't know and end up signing things, and it ends up. A whole other thing that I could talk about, and I don't want to spend too much time on this, is because we have in this country something called dual sovereignty, which means that the federal system is slightly different than the state system. Both can choose to bring a case ahead. And because one is exonerated or not exonerated, what's the word I want to use? Found not guilty on one venue doesn't mean that those same charges can't be brought up in another venue. I know someone, again, when I'm telling you these things, it's not just something I read. Every time I say I know someone, these people's pictures pop in my mind. I know someone, I remember him, he was really peed off, and you'd be peed off if this happened to you. He was charged with murder in the state, found not guilty at the state. The federal brought it. Same body. He was found guilty. And he said, you don't understand how much my children are. He was really caught up about it because it really affected his children a lot. He said, could you imagine what it's like to be in a courtroom and they say not guilty, and then 2 years later, they say guilty for the same exact thing? And he couldn't understand why it wasn't double jeopardy, and I didn't think that that was the time for a legal discourse on my end or intellectual discussion on dual sovereignty. But the fact of the matter is, because we have dual sovereignty, him being tried and I don't know why the word has escaped me because it's not exonerated, but found not guilty, vindicated, I guess you could say, in the state level, had no bearing on the federal bringing it. And in some cases, federal prosecutors will wait for the state to bring charges just to wait and watch and see how their case went, to see how they can make theirs better to convict. That happens as well. They might wait either to bring the charges, because in a case like murder, there's no statute of limitations. They'll watch the trial. They'll see what worked and what didn't work. And that's what they did with him. And then the feds brought the same exact, I don't want to say case, because it wasn't the same case. It was the same body. But they brought it, they had their own prosecutor. They brought a whole different legal team. And he was found guilty. So I say that to say, this goes back to ignorance. People sign plea deals not realizing, well, how could that have happened? Because again, that plea deal, if it was with whatever prosecutor, that prosecutor, and that case, there wouldn't have been a plea deal as he went to trial. But that prosecutor would have been a state or federal prosecutor. There's no plea deal that gets to make a decision for both federal and state. So even still, it still only is limited to that one venue. So I want to give a practical structural point that I want to see happen here in this country. I believe that there should be no such thing as a plea agreement. I believe that one of the ways to structurally change the system, this would be big, this would be massive, is that everyone who is charged with anything, for the prosecution to move forward, they should have to bring them to trial. Period. Now that would do a number of things. One, it would overwhelm the system. That's why they work on pleas so much now. You know, like I said, over 80% is done by pleas. I think the numbers are much higher, but at least 80%. Because the government does not have the resources to bring all these trials to bear. But this is the question. If they don't have the resources to bring the trial to bear, why are they arrested? And if everybody at one time exercised their right to a trial, everybody, I'm not talking about everybody on one case, everybody in one city, I'm talking about everybody nationally who was caught in anything said we are no longer taking a plea. Everybody said we are going to trial. It would collapse the system as we know it. So I think that the right, because a right is not a right if it can be so easily taken away and so callously taken away. So the right to a jury trial, I believe, should not be a right. It should be mandatory. If the government feels that strongly that this person's life, freedom, and livelihood should be taken away, then they should have to take it to trial. So what happens is people always talk about found guilty peer of their jury of their peers. Most people never get to the jury of their peers because they never were found anything. They pleaded because they knew if they went to jury, it would be a whole nother thing. So then that would phase out the trial penalty because everybody has to go to trial. And I guarantee you, if tomorrow the system was such that everybody that they charged, they would have to take them to trial, one, it would significantly decrease the number of charges that they bring. It would exponentially decrease the number of arrests that are made. And it would now be focused on charging the most serious of offenses and not this frivolous charging where now you can, on one indictment, bring down 100 people. Because that's what they do. And of the 100 people, 90 of them took a plea. Because 90 of them said, we ain't about to do that. Especially when you got one that said, I'm going to tell. That's why people don't like snitches so much. Because what happens is, that's the loophole in the system. So you get one that says, I'm willing to testify on all 100. 90 of them are going to say, I ain't going to take a chance of that. Go back to the first degree burglary. Let's say it was other people involved. And maybe they are able to make the case that it wasn't, I didn't have the gun and all this other stuff. But you got one person that says, no, I know him and I knew he had the gun and he threw it out the window. And I'll stand on the stand and I'll say what he did. That's the other thing a lot of people don't even know. Most people that are labeled snitches, they never even made it to trial to sit on anybody's trial because when they gave their, their plea allocution, when they told their story to the prosecutor, when the people who were defendants read that story, they said, oh, I ain't going to trial with this. So I think that one structural change would be every charge that is filed by prosecution, they should have to take it to trial. They should have to take it to trial. They should absolutely take it. It should not be so easy to throw people's lives away for 20, 30, 40 years in life sentences. It should not be so easy where they can sign one indictment and have 100 people on it and 90 people, they don't even meet the 90 people. 90 people now have, and they may not have ranging sentences, 5 years, 10 years, 20 years, just based off of paperwork. I think partly the reason why this goes the way that it does, the penal system, is because it dehumanizes people. See, what trial does is, even though it's demoralizing, some aspects aren't dehumanizing because you got to look that person in the eye. It's different. See, prosecutors, part of what they get their mojo on is that they're able to do everything through paperwork. Imagine if you could sign away the fact that you know someone's life is now going to spend 20 years behind bars. You never had to meet them. It would be an easier decision. It's no humanity in that because now you just sign the paper and you're like, hey, let the chips fall where they may. And they're able to sign the paper and they go out with their colleagues and have drinks afterwards. Because it's no type of emotional attachment, at least when they're forced to go to trial. Because I know some prosecutors personally, they're stressed about trial. They don't want to lose trial. They don't want to look crazy. They don't want the other lawyer to embarrass them. So now it's an emotional aspect. They at least have to look in the eye of the person that they're filing the charges against. And so I think part of how we structurally change the system is not just about creating things that make it harder for prosecutors, but I think what you have to do is create a system where, excuse me, there's some level of humanity. Now with COVID, you got judges sentencing people and they're not even in the same room. I have a big problem with that. I have a big problem with that. And you're gonna just say as a judge, this person gets 20 years, and you never even met them. You never even got to lay eyes on them, or maybe it was a computer screen. Sorry, excuse me. But you never even got to have them in the room. How is a society that we get to a place where we find that that's okay? I mean, they won't even hire you at the Wendy's without a face-to-face interview. And you mean to tell me I can take somebody's freedom for 20 years and I never even met them? I can sign a document and that be the end of it? So without getting into a rant, structurally, it should be that every charge that a prosecutor files, they should have to bring it to trial. That would change the system overnight. A quarter of prosecutors would just quit because they feel like they're buried in paperwork now and they wouldn't want to go through the hassle. Good. Go ahead and quit. Because we need people that are willing to, if you feel that strong that person needs to spend the rest of their life in jail or 10 years in jail, look them in the face. Don't just make it about paperwork. Look them in the face. Look them in the face. Practically, what can you do? If you know somebody that has a plea that they're looking to take, you need to tell them to watch this video. Before you take any plea, you need to watch this. Because, yeah. You need to watch this. But beyond that, if you have a plea, read it carefully. These pleas are not, even though your lawyer may just show it to you, you can get a copy of it, show it to somebody else, have somebody else read it. Check your blind spots. Look at everything that's being said. It's an agreement. It's a contract. It's just like if you were to go and buy a house, and it's the fine print that always gets you. You know, I remember about 6 months ago, we went to go, I forget what activity it was. I can't remember what it was, but it was a museum where there was physical activity. And I look in the what do you call it, the fine print, and it's talking about if you fall and break your neck, we're not responsible. Wait a minute. How am I going to fall and break my neck on this exhibit? I thought we were just looking through binoculars, but then I find it's all this other stuff involved. Read the fine print. There is fine print in every contract, just like there's fine print in every plea agreement. So very practically, before you tell somebody and advise them, you should take that or you shouldn't take that, read what's in the agreement. Have a candid conversation with them. Is there anything else that's not considered this agreement that could come up? I understand that there's more stuff in your past that you're hoping they don't find out, but just be aware, if it comes out to the surface, this agreement is balled up and they wash their hands of it and they're going after you. Have those conversations. Moving forward, we're going to talk about a lot of other things. We're going to talk about the RICO laws. We're going to talk about how federal system is different than the state system. We're going to talk about how different laws have been made specifically to ensnare certain populations of people, because we ain't even going to play like that's not the case. Because there are certain laws that they know that they passed it because it was generally applied, but it was meant to ensnare certain groups and segments of the population and even certain geographies. And we're going to talk about certain things about like vagrancy laws, how homelessness has been criminalized. Because you say that you have vagrant laws, but if every property is owned and someone has nowhere to live, that means that anywhere that they sleep is considered trespassing. So now their being is being criminalized rather than their doing. And I want to talk about that, how there's certain laws that criminalize being versus doing. Just the very fact that the person's present means that I want to talk about thought crimes. I want to talk about how conspiracy is actually a crime. You can be charged for what you thought about or what you agreed to, even if you never really did it, even if you never had an intention of doing it, even if your agreement was only with a law enforcement officer who was working undercover. So you might try to make the argument, like some have in the past, well, it's really not a real agreement because the other side didn't have any, never was going to go through with it anyway. But that doesn't matter. You can still be charged with conspiracy, and people generally are. And I'm going to talk about how the practical effects of what felonies do moving forward on people's lives, how it affects where they live. It affects their ability to get certain jobs. It affects their ability to get certain professional licenses. I told you here in New York, if a person has a felony in New York, they don't let them have a barber's license. For real? A barber's license? So you can't be a barber because at any point at some time in your life, you had a felony? Or I think some of that has been changed. So let me look at some of how the laws have been updated. But maybe you have a felony, you get a barber's license after a certain number of years. But that's the other part. If you served your time, you served your time. I don't understand why continue to lock people out of these level of jobs. And I want to talk about how we can have some systemic change. There's other things that I have, like removing mandatory minimums. They just need to be removed. You've heard about MAD, Mothers Against Drunk Driving. You probably haven't heard about MAM. There is a such thing, MAMM, Mothers Against Mandatory Minimums, because there's a lot of mothers who are visiting their children in prisons across this country because their children were convicted of crimes where there was a mandatory minimum. And somebody else did the same exact thing. And because they weren't charged with that, they didn't get any time. And their child is serving 10, 20, 30 years for a mandatory minimum. I want to tell you about stacking. How people get certain charges, and because it means that it's stacked, it can't be concurrent. It can be consecutive. I know we don't know what those two words sometimes mean, but consecutive means that now certain charges are stacked. Meaning, so if they have 3 of those charges and they're 5 years, you may not realize, but now the 5 years have to be served 5, 5, 5. It's 15, as opposed to someone else that was able to push for it to be consecutive. Concurrent, and now they just do 5. So those are some of the things I want to talk about. My name is Darrell Bennett, Come Back Swinging, and I do want you to know you can find me on all of the platforms. Darrell Bennett. You can find me on darrellbennett.com, DarrellBennett. I'll make sure the link is coming across the screen. I want you to know that now is the time that we have to begin to talk about some systemic, real change. And I am ready to be a voice of justice because I've been there, I've done it, I've seen it, and I think that this is our time, this is our moment to really seize the reins and to make some systemic change in this country and change entire systems.